Good evening, everyone. We're now on record. I'm going to call the meeting to order at 5:30 p.m. Present, we have Wendy Wendy Smith, who is the chair of the Board of Appeals Committee. Also present is John Tutenhoff, Stephen Isaacson, Cara Espera, and Kevin Matthews. This meeting has been properly noticed and posted according to law. And now I will turn it over to Chair Wendy Smith.
All right, good evening. This is the Board of Appeals meeting subject to the agenda packet distributed to the public and the members. The first item for consideration on the agenda is marked number 2, approval of the minutes for our meeting on September 10th, 2025. Are there any suggested edits or revisions for this draft of the minutes? Hearing none. I have no suggested edits. The minutes are approved as drafted. The third item on our agenda is relating to the fourth item on our agenda, which is the only material item on our agenda, the consideration of George Washington 1776 Lodge 337's appeal of the denial of its commercial occupancy permit. We have Attorney Worth here to advise the board as to the standards of review that the Board of Appeals must abide. Attorney Worth, do you want to describe those standards now, or does it make sense to have any kind of introduction to the issue? It's up to you as to whether you want to jump in here now.
I think it probably makes sense to give a global introduction to what you'll be deciding this evening and incorporate within that the kinds of standards you'll be looking at.
Okay.
If it's okay with you?
Go ahead.
Okay. As you've heard, first of all, I want to make sure the record reflects that the agenda packet that you received earlier has been updated or annotated with a copy of Director Grippentrog's email of Thursday, October 30, 2025 to representatives of the appellants, relaying his decision on their application for commercial occupancy. What you've got before you this evening is an appeal on behalf of, as you indicated, the George Washington 1776 Lodge regarding its application for and subsequent denial of a commercial occupancy permit for the property at 4121 North Wilson Drive. So for tonight's consideration, you are not faced with a variance. You are not faced with a special exception request. This appeal is for your evaluation of the interpretation of ordinance-based refusal to allow the construction, development, commercial development, and occupancy permit of that property. The appellant proposes that the Planning and Development Department made an error in its interpretation and application of code requirements that the lodge's primary use of the property would be for what is referred to under our code as commercial or community assembly. Under 535-55, your options in this appeal are to affirm the decision wholly or partially, reverse the decision, or direct any modifications that you may decide upon that would allow the permit to issue. You can also adjourn tonight's proceedings if you determine after the presentation by the village and by the appellant that you need consideration or additional assistance from any other departments, including seeking additional legal guidance. You are reminded that you sit as a quasi-judicial body required to make your decision upon the evidence presented this evening. And I would encourage you to be prepared to elaborate on the reasons and the rationale, the bases for your votes in this case. Although the record becomes part of the recording becomes part of the record, it always helps to hear your evaluation and your decision-making process. The operative application for a commercial occupancy permit was filed with the village on or about October 2nd, 2025. By the email you now have dated October 30, 2025, Village Zoning Administrator Bart Griepentrog Advise the applicant that its application for the requested occupancy permit and construction was denied. This appeal to the board was filed on or about November 5, 2025. The date of today's hearing is December 11th. The appeal is premised upon the applicant's contention that its proposed use was erroneously classified as community assembly. Definition that you'll be relying upon in the ordinance for community assembly is the community assembly use category includes facilities for housing public or private meetings, including senior centers, community centers, municipal-owned performing arts centers, and religious institutions. It also includes fraternal organizations and similar not-for-profit clubs restricted to use by dues-paying members and their guests. The property itself is zoned GX2, General Residential and Office Mix 2, the 2 being designation of size of the property is permitted. You will hear that community assembly is a permitted use in the GX2 zoning district, but is subject to location restrictions within the subject property. Based upon the floor plan and use explanations within the application materials, the zoning administrator denied the application for occupancy. You are encouraged to focus your evaluations today, this evening, on the reasons for the appeal that are contained in the application for appeal. To the extent you have questions about either your jurisdiction or your authority outside the specific application, I'll be prepared to answer those. Just feel free to ask. Other than that, I'll turn it back over to the chair.
Any questions for Attorney Worth at this time? Hearing none. How do we propose this? Is this a case where the appellant would like to make an introductory statement first? Or are we asking the village to defend its position first? I'm not sure what the right process is.
I would probably suggest that the applicant.
All right. Counsel for the applicant is here.
I'm going to take your instruction. Thank you very much. My name is Debbie Tomczyk. I'm the attorney representing the applicant, and I do also have a PowerPoint that I'm hoping would be part of the record as well. So first of all, appreciate your doing this on a icy December night right before the holidays. So appreciate your attention and the opportunity to appear. So just again, great introduction already as to why we're here today. But just to ground everyone, I always think of pictures are worth 1,000 words. This is a picture of the site, an aerial view of the site, and it's circled in blue. You'll notice that Wilson is on the east, Capitol Drive is to the south, and then the Oak Leaf Trail is to the west. There's also a very large transmission tower immediately to the west, and to the south is the police department. So just to orient everyone, if we could go to the next slide. Here's the picture of the actual structure that's on the site, just to, probably you're familiar with it, but just again, picture worth 1,000 words. We could go to the next slide. This was built in 1940 for the North Shore American Legion Post. And it was used as the North Shore American Legion Post for 79 years until 2019, when the American Legion sold the site. Next slide, if we could. Just again, the site itself does have some challenges for operation, for reuse. It is a narrow site, especially to the north. You'll see there's a connection to the Oak Leaf Trail that's labeled. The property to the north of that is virtually unusable other than for green space. The building is relatively small. That large transmission tower actually has ice falling off of it, which I think the police have also experienced as well. So a lot of things going on at the site, not to mention the police is a great neighbor, but depends on what your occupancy is. If you're sleeping there, maybe not such a great neighbor if the police are occupying for 24/7 and having sirens and traffic coming in and out. If we could go to the next slide. They're also, just to explain some of the other things that are going on at the site, the access is the access that's provided to the parking lot. And actually, the police have a license to park at this location as well. Their only access would also be through the driveway to get to the 4121 Wilson property. And then we allow them to park along their building as well. And of course, that can continue. We're hopeful that we'll be able to figure out a way forward to reuse the site. If we could go to the next slide, just again to orient you to some of the challenges that the site faces. It is a very small, narrow site. It is just over a half an acre, very small, very difficult to reuse. The building itself is very small. It is a tri-level building, so there's 3 different levels, but a total of only 4,400 square feet. That's roughly just a little bit bigger than my house, for what that's worth, probably a little bit smaller than some of the houses that are in the village here. And on the 3 levels, the 2 main levels are about 2,000 square feet each. And then there's an upper story attic of about 472 square feet, but it's also a tri-level building. And we'll get to that in just a second, with a police neighbor again, with 24/7 operations, and then that high tension wire immediately to the west. We can go to the next slide. As I mentioned, this North Shore American Legion developed the site, developed the building for a similar type use, actually has used the site for 79 years for a similar type use, but then sold the site in 2019. It's been relatively unused, certainly underutilized for the last 5 or 6 years. It's owned currently by a developer, very good developer with very good experience to be able to redevelop a site. So I think there was a hope that maybe a residential use, commercial use, condos, apartments would be possible. I think that, and what I would observe in the market too, that's not really feasible for a site of this small size with this small of a building on a tri-level configuration. So what we're proposing is to reuse the site in what we think is the highest and best use, which is also very consistent with what was the 79-year use of the site and how it was developed in the first place. The Masons are also prepared to substantially invest in the site, to bring it, make it active again, to improve it, to upgrade the physical presence of the site and its value and its operational use. The next site is a little busy and hard to, it is right, the use provisions right from your code, but I think it's hard to read. It didn't come out as well as I would have liked. What I was trying to illustrate, and as Attorney Worth indicated, the community assembly use is permitted, as are event venue uses and office uses. So all we're talking about today is permitted uses. What we're talking about is which one of those permitted uses should apply. And as Attorney Worth indicated, if we're classified as a community assembly use, which is how the building inspector has classified us, we have additional locational restrictions that are being imposed, which were not something that the Masons had to comply with. And it is something that adds some additional challenges to reuse of the site. If we could go to the next slide. Language is important as we're talking about how the code should be applied. And again, the community assembly use is a permitted use, but with these locational restrictions. I think the language is worth spending a couple minutes on. So your code defines the community assembly use category to include facilities for hosting public and private meetings, including senior centers, community centers, municipal-owned performing arts centers, and religious institutions. It also includes fraternal organizations and similar not-for-profit clubs restricted to use by dues-paying members and their guests. Seems like a reasonable fit, but I don't think it's the only fit. And again, if we follow that code, the community assembly use is permitted a right, but only when it's located above the ground floor in upper stories of the building or in the rear of the ground story, a minimum of 20 feet from the primary facade, right out of your code. So if we could go to the next slide again, just the same picture, but you'll notice our lower level row of windows is only half showing because it's a tri-level building. So that level is below. Then we've got the main level of windows and then a small attic above. If you'll go to the next slide and look at the floor plans of the 3 floor plans of the building, you'll see that we're only 30 feet of depth. So from the front facade to the back facade. So if we're talking about only being able to use beyond 20 feet, that leaves us only 10 feet of usable space for the building under this classification. You'll see that when you walk in, there's the tri-level entry, but there's also on the first floor, event venue space and also a stage as well. But it's a challenge configuration primarily because of only 30 feet depth from the front facade to the back facade of this particular structure. So if those locational restrictions are applied, we will not be able to use this site as it was originally developed, as it was used by the American Legion Post for 79 years. And we would argue for the highest and best use of the site, making it very difficult to be able to reuse this site and put it to a productive use. As a tri-level, it's not really clear what is the ground floor, what is the basement, what's the first floor, what's the upper story. None of those things are defined in your code. Again, the entire depth of the site and the building is only 30 feet, leaving us just 10 feet behind that initial 20 feet from the front facade. But most importantly, if we look at the language from Community Assembly, that definition is not the best description of what the Masons are proposing to use this site for. The Masons will not be hosting public meetings. They will not be establishing a senior center. They will not be establishing a community center. They will not be establishing a performing arts center, nor will they be establishing a church. They will also not be restricting their use to dues-paying members and their guests. So many areas of that definition simply do not apply to what their proposed use is. Next slide, if we could. We think that the best representation of what we're proposing to do is office and event venue definitions under the code. And again, the language is important. So the event venue is a multi-purpose venue facility hosting special events such as graduations, weddings, anniversaries, holiday gatherings, trade shows, corporate functions or parties, concert settings, and general get-togethers. An event venue typically includes indoor and outdoor or outdoor seating and a stage or event area, but not a full service kitchen. That fits our use, that fits this building better than the Community Assembly definition that was provided. The office use is also primary use for what the Masons are proposing. Office use category includes workplaces of private companies, organizations including for-profit and not-for-profit, and public agencies providing professional executive management, medical, administrative, or design services. And we expect to have not just the Masons and the Masonic Lodge at this location, but also the Children's Dyslexia Center and the American Legion, who's going to come back home from where they have moved in 2019. If we could go to the next slide, just bear with me for the floor plan again. There were physical callouts in what the definition of the code says is appropriate for the event venue space and the office space. Needs to have an existing stage or a stage. This property does. It has a stage. It needs to have indoor and outdoor seating. There's certainly indoor seating. There's also an opportunity for outdoor seating for our gatherings as well, which is what we're proposing to improve over the existing condition as well. And that's on the ground level. We go to the next slide on the first level where all the main building windows are. This is where we would have workplaces, the office space, as well as event space. And we don't have a full service kitchen, but we do have a kitchenette, which also fits the definition of what is an event venue. And then the third story does not actually have a bathroom or plumbing service either. So it would be office space or modest event space, but the building is set up for the event venue office uses that we're proposing. We think that our use and how we're proposing to use this meets the plain language of the event venue and office definitions in the village's code. And again, our other users will be Masons, Children's Dyslexia Center, and the American Legion, all of whom will be using this for their general get-togethers, for meetings, office space, and for training sessions, for special events, things that have happened at the Mason location in Whitefish Bay and that we'd like to relocate back to Shorewood. Ironically, the Masons were in Shorewood a number of years ago as well. The site is physically configured just for such uses and includes all of the indoor and outdoor seating areas, office, event areas, kitchenette, but not for full service kitchen, and office workplaces that are defined in the code. We go to the next slide. The community assembly, event venue, and office uses, again, are all permitted. I think, as Attorney Worth indicated, it's important that we're not talking today about a variance. We're not talking about a deviation from the code. We're talking about, actually, in all three instances, community assembly, office, event use, event space, all three are permitted uses and are consistent with the code definitions. The Masons just seek to reuse this site the same way that the American Legion had used it when they developed it and as they'd used it for the 79 years of their occupation, without the additional location restrictions that were not imposed on the American Legion either. If the village interprets its code to impose those additional locational restrictions on the Masons' use, which it did not apply to the American Legion post for 79 years, and which also do not apply to other applicants with similar type uses, we're focusing on the user, not the use. Zoning is supposed to regulate use, not user. We go to the next slide. This is Rathkoff's is the preeminent sort of zoning treatise to explain to us how to administer a code. And just a quote that's also in your materials: despite the widespread zoning practice to the contrary, zoning restrictions, conditions, and decisions which limit the use of land based on identity or status of the users of the land are generally invalid on either due process or equal protection grounds. Those restrictions must also be held, could also be held ultra virus, and state courts have held that a zoning enabling act authorizes a municipality to regulate the use of the land, but not the status or identity of the land user. Zoning has to deal with land use, not the owner, not the operator, not the occupant. Your code recognizes this. 535.25B4, which is how the building administrator figures out where to classify a particular use, focuses all on uses, use type criteria, not who the user is. The criteria that are to be applied are the types of activities that will occur in conjunction with the use, types of equipment and processes to be used, existence, number, and frequency of residents, customers, and employees, parking demands associated with the use, and other factors, but all focused on how the land and building are used, not who the user is. Applying the, if I could go to the next one, applying the village's code to regulate who is using the site, which is in effect what would be happening if we're saying it's okay for American Legion, other similarly situated users, office and event users, but not the Masons, could violate the due process and equal protection rights of the Masons. And this would be particularly concerning because the village risks violating the Religious Land Use and Institutionalized Persons Act of 2000. Our LUPA prohibits the village from imposing or implementing its zoning regulations in a manner that would treat a religious assembly or institution on less than equal terms than a non-religious assembly or institution. The Masons' proposed uses have to be classified as event, venue, and office to avoid due process, equal protection, and our LUPA violations. So you have the ability to make sure that this is a non-issue, that allows the property to be used in a consistent way with its past use, and avoids any future process that might be associated with these concerns. Just one last slide. in the Department of Justice website, where they're the enforcers in many cases of our LUPA, they have a frequently asked question number 12, which says, what does our LUPA require of local governments with regard to treating religious assemblies and institutions as favorably as non-religious ones? Our LUPA contains a section known as the Equal Terms Protection provision, which provides that no government shall impose or implement a land use regulation in a manner that treats a religious assembly or institution on less than equal terms than a non-religious assembly or institution. Happy to answer any questions and appreciate your time and attention.
Any questions for the petitioner's counsel?
Can you give us some background on the action developer bought? Some reason did not go through with the plan. So I assume you represent.
I represent the Masons, correct?
It's about-
Would be the purchaser of the site from the developer.
There been a price?
I believe it's under contract, yes.
Can
Correct.
you tell us why the developer, why?
I'm going to object. That's totally irrelevant.
Okay,
It doesn't matter.
all right, fair enough. Point is, there was no transaction, nothing. Building remained.
So the transaction between the American Legion and the developer did occur in 2019, because again, the original owner and operator of the site was the American Legion Post.
Right, but the developer had not done anything to the site?
The developer has not developed the site at this point, or redeveloped the site at this point. It's been largely vacant.
I'm going to
Go ahead.
interject one thing in case you want to comment on it. Tonight's process is to consider the rationale for the appeal that's in the application. And what's in the application is a challenge to the classification of the applicant, not for LUPA, not the potential constitutionality of the ordinances, apply the ordinances that currently exist, getting into or LUPA, getting into legality of the ordinance itself is I'm going to suggest and beyond this board's scope. This board's scope is to determine the bases and rationale for the.
If I could respond?
Go ahead.
Valid questions and concerns raised. First of all of this material is referenced in our materials, but the point of tonight is we don't have to get to the due process, equal protection, our LUPA claims, if this board would find that our interpretation of the proper classification of the code, which we think meets the plain language of the code, is appropriate.
I'd like some clarification on what the position is. Is the George Washington 1776
Yes.
Lodge number 337, I wanted to get that right.
You said it better than I did.
Would you categorize that as a fraternal organization?
You know, would I categorize it as a fraternal organization? I think we're all in the world right now a little at risk for how we label things, because people interpret their identities differently. But is it traditionally what you would say is a fraternal organization? Yes, I think it is. But I also think that goes to who the user of the site is as opposed to the use.
Okay. Would you also categorize George Washington 1776 Lodge number 337 as a religious institution?
As a religious institution, no. But I would categorize them as a membership that is devoted to a supreme being, that has guiding principles and rituals that have to be followed.
And so, and I know that Attorney Wirth has advised us to skirt the RLUPA provisions, but does that apply to religious institutions?
Our LUPA definitely applies to religious institutions. I think the case law, and maybe now we're going to go farther afield, but also recognizes that institutions that are, or organizations and users who have a more tenuous relationship with religion are still covered by the RLUPA. So for instance, there's many of them are homeless shelters right now in California that are dealing with similar, that they're acting out of their Christian beliefs. They're not established religions, but they are covered by RLUPA and they're being defended by Department of Justice.
Okay, so maybe phrased differently, does the organization have a religious purpose?
I'm not sure what that means.
Is it part of its charter or goals or mission to serve a religious purpose?
It is part of its goal and charter and mission that it serve its community and that it train its members and its affiliated entities to similarly train in consistent with what its divine being would direct.
And then I just have one question before I can turn it over to other folks. For the category that is the commercial use group, which I believe was referenced the subsection D, and I understand that there is reference to the event venue subsection as well as the office space subsection. But the very beginning of D asks, the commercial use group includes uses that provide a business service or involve the selling, leasing, or renting of merchandise to the general public. Maybe you could provide a little bit more information about whether the organization is providing a business service?
It is not providing the Masons are not providing a business service. They're serving their community. They're also, though, however, making the property available and would make well, they don't own it yet. They would make the property available for use as an event venue by other folks. The Children's Dyslexia Center would also be operating that for what are more traditional business type services in terms of training sessions, serving that community, consulting services, et cetera.
So do they intend to charge for those services?
They do intend to charge for those services, yes.
Okay. Other questions for council?
When you're talking about the event, are these or?
No. And in fact, our chart, and we have significant information that we provided to the building inspector. Our hope is that we can make this event available. I mean, it's a small space, right? It's only 4,400 square feet, but for other birthday parties and anniversaries, et cetera, on a rental basis. For non-dues paying members, not affiliated with the Masons.
But do you agree that the community assembly subsection contemplates using the facility for hosting events?
I believe all three of the categories that we talked about tonight, including community assembly, can fit. I think, however, to avoid getting into any of the other issues that we talked about, a very reasonable reading of the code is to classify us as an event venue and office and issue our permit.
Other questions at this time? Any other information you'd like to provide currently? Or I mean, we may come back to you have follow-up questions, but
Just again, to clarify that our PowerPoint would be part of the record. Correct.
I'll note on the record that do we have a copy of the PowerPoint so that we can retain?
Absolutely.
Okay, so that can be entered into the record for consideration. Thank you.
Thank you.
Attorney Bayer, would you like to make a statement on behalf of the village?
Sure, thank you.
Thanks.
Okay. I know where to find you.
So thank you, everyone. A couple of points that I want to make right away where we differ and then where we can find some common ground on what was presented on behalf of the lodge. We do not agree in any way, shape, or form that office and event space uses are permitted uses here. The reason that is wrong, and I'll get into this a little more, and we'll talk about it, principal uses versus accessory uses and what the real problem here is. But the other main point is that whatever the Legion Post did when the Legion Post was there, whatever uses were allowed or whatever they did for the number of years that they were there is totally and completely irrelevant. And the reason for that is that the zoning code is different than it was when the Legion Post was there. So I want to work from the 30,000 foot view down. And the main problem that we have here is that there's a difference between principal uses and accessory uses under the code. And I want to talk about those. And I've handed out a couple of exhibits that include a portion of the Shorewood zoning code and talk a little bit about those. So if we work from sort of, the large picture down to the details, what we have here is, again, the property is over on 4121 North Wilson Drive. We saw pictures of it. And the applicant is the George Washington Lodge 337. And they were denied a commercial occupancy permit based upon the zoning district. So that district, and we've highlighted it here, that district is GX2. And that's general residential office mixed use, right? So if we scroll down, there's a chart there that tells us what type of uses are allowed, what type of uses are permitted as of right, what are conditional, et cetera, et cetera. And if we go to page 3 of 11, you can see it's highlighted there, community assembly. And we've heard some things about that thus far. And there's that funky looking upside down circle with the top shaded in. So lower on that same page, we have the highlighted. What does it mean? It says permitted as of right, subject to local restrictions, location restrictions. Uses identified with the upside down circle, half filled on the top, are permitted as of right in the subject zone, but only when located above the ground floor in the upper stories of the building or at the rear of the ground story, a minimum of 20 feet from the primary facade. The first 20 feet behind the primary facade must contain occupied building space of an allowed use. And then it says C3 or 535-6A for definition of occupied building space. And I think there's common ground here. I think that the lodge has admitted that they cannot fulfill those requirements, or they don't meet those location restrictions. So we're all in agreement on that. So the second Exhibit B that I handed out talks about accessory uses and structures. And here's what it said, and this is probably the most important language for you to analyze this evening, and it's the most important portion of the code that we'll talk about. Here's what it says. Accessory uses are allowed only in connection with lawfully established principal uses. And I'm going to use the Monopoly analogy. If you've ever played Monopoly and you pull that one card, it says do not collect go, or do not collect $200, do not go past go. Your turn is over. That's essentially what this says. If you don't have a primary use or a principal use that's allowed, you never get down to the accessory uses. And what they're talking about with respect to accessory uses is the office and event uses that they're going to also have, right? Because there's no way around the fact that the primary use here is a fraternal lodge. And I want to go back to 535 Exhibit A one more time. And I want to move a little bit further into that exhibit. I want to move ahead to, you'll see some additional highlighted materials. There's another acronym called KISS, Keep It Simple, Stupid. And that's really all this is. This is not complicated in any way, shape, or form. Page 9 of Exhibit A, which is 53525. There's a definition there for civic and institutional use groups. And sub 2 is the one that we're talking about. We're talking about community assembly. It says, the key language that's highlighted, it says that it also includes fraternal organizations, full stop. It also includes fraternal organizations. So the question here is, if they're a fraternal organization, and there's no doubt that that is the primary or principal use, it's disallowed under the code, has nothing to do with what the lodge did there previously or the American Legion Post did previously, has nothing to do whether the developer had an opportunity to develop it and did or didn't. Doesn't matter. Any of those things are completely irrelevant. It comes down to, if you believe that the principal use here is as a fraternal organization, it's not prohibited. It's prohibited. It's not allowed. And you never make it to the accessory uses because of 535-26, which says accessory uses are allowed only in connection with a lawfully established principal use. So again, it's the monopoly analogy. Do not pass go, do not collect $200. That's the end of the analysis. So with respect to that, I'd like to pull up, if we could, if we want to look at I'm wondering if could we pull up that link by chance, Madam Clerk? And I believe do we have anyone here from the lodge? Would one of them be able to confirm that this is the lodge's, George Washington Lodge's website? Okay. Could we click on links to the right where it says officers, files, links? Yes, right there. Okay, so is it also fair to say that this links with the home of the Wisconsin Grand Lodge? There's a link on the website for the local lodge. Is that fair?
You probably are going to have to
Yeah, I'm gonna-
be careful that we get a
I can
microphone in
explain
front of
real quick. So is it a website affiliated with us? Yes. It's created by our membership database. It's more of an automated thing than an actually curated list of things. So for instance, it is not a calendar of what's happened in our previous building. It's not really useful for the public.
Well, why don't we have you just introduce yourself?
Yeah, hi, I'm Tyler Christopede, and I am the secretary treasurer. I'm also a trustee.
Does he need to be sworn in?
I think you should be sworn in.
Toy.
Can you raise your right hand, please? Do you affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Can you state your name again for me, please?
Tyler Christopede,
How do you spell that last name?
Aristopeit.
Thank you.
So there's a link on your website to the Wisconsin Grand Lodge because you're affiliated with that group. Is that
Correct.
fair? Okay. So let's click on home for under Wisconsin Grand Lodge. Further down,
Under
under
Grand
Wisconsin.
Lodge.
Yeah, there we go. Okay, so that was what we just looked at was Exhibit C. I want to look at Exhibit D. If we look under what is Freemasonry, about Freemasonry, and click on that. And we scroll down a little bit more. Okay. So there, the lodge, the Wisconsin Freemasonry website that yours connects to, the first sentence under what is Freemasonry, it says, Freemasonry or Masonry is the oldest fraternal organization in the world. Is that right?
We are, yes.
Okay. Let's click under, so that was Exhibit D. So let's click under what is, if you click under what is Freemasonry, there should be a frequently asked questions a little down there. Okay. If we click under what is Freemasonry there? And am I correct in reading that the first sentence says Freemasonry is the most widely recognized fraternal society in the world? Okay. And then scroll down a little more. There's a question, is Freemasonry a religious organization? Let's see if we can find that one. Oh, there it is. Is Freemasonry a religion? So the first thing it says is no, Freemasonry is not a religion, nor a substitute for religion, correct? Okay. So generally the main, all of the main meetings for the fraternal organization that will continue, or that would continue in Shorewood, would be a carryover of the meetings that the Fraternal Lodge held in Whitefish Bay, correct?
I think we're in position of a cross-exam.
Well, okay, if he doesn't want to answer that question, that's fine. At any rate, if you look at these links, Exhibit C is an excerpt, or I printed out the website of this particular lodge. Exhibit D is the link to the homepage for the state organization. Exhibit F shows their own definition. Freemasonry is the oldest fraternal organization in the world. That's the first sentence that they voluntarily chose to how to identify themselves. Under frequently asked questions, the first sentence that they chose to write is Freemasonry is the most widely recognized fraternal society in the world. And under whether or not it constitutes a religious organizations, it clearly says that they're not, and they're not affiliated with any. So the problem here is that the primary or principal use under 535.25, under that definition, there's no doubt that it is as a fraternal organization. There's no getting around that. That's the primary or principal use. And the problem with attempting to flip the script is to say, well, we have office and event venues. Sometimes, well, it's their own office. I mean, it's the office of the lodge that is a fraternal organization. So that's a self-serving claim or identification. It's still a fraternal lodge. And the fact that they might have events once in a while where the, members of the public or family members of those that are part of the lodge could come forward and host a birthday party, a wedding, whatever it might be, is essentially irrelevant because we never get past the principal use. We don't have an allowable principal use, which I think is essentially undisputed. So that's ultimately the main problem. And I'll go back to, again, the analogy with respect to monopoly: do not pass go, do not collect $200. We never get past principal use being as a fraternal organization for the Freemason meetings. That's what we're talking about here. So it might be a wonderful organization, and they might do good things, they might do charitable things, but the whole point of a zoning for a municipality is to say, what do we want where? Is it going to be taxed? Is it going to be exempt? Is it going to be, how are we going to promote development? How are we going to promote, economic advancement of the municipality? And all of these things are extremely important because you have to remember, under the limitations that are put on local municipalities, it's grow or die, right? Your levy limits and other budgetary constraints are defined, are year by year limited to your net new growth. So if we start to willy-nilly change the zoning districts and allow this type of thing, whether we're going to have exemptions, it flies in the face of the entire point of the underlying zoning. So, again, it's not about whether it's a good organization or not. There's no doubt they do wonderful things for the community. There's no doubt that, they've been around in the area a long time. The only problem is we have designated, the village saw fit to designate this district as GX2, which is General Residential Office Mix 2. And the primary use here, or the principal use, is restricted. There's no dispute about that. Everybody agrees to that. And to try to flip it and say that, well, the main use is office and event venue, and it's not really, the principal use isn't a fraternal organization, is completely belied by all of the things in their own promotional materials. So I think that's the main problem is you can't get past that principal use. Again, I want to stress that whatever happened in years past with respect to the Legion post is totally and completely irrelevant. And I believe that Bart Greifentrog's letter to the applicant indicated that, hey, they said, well, what about the Legion post that was there? And that in 2023, the zoning was changed. And so it doesn't fit because something fit zoning 75 years ago or 50 years ago or 5 years ago or 3 years ago. Doesn't matter. What the Legion Post did or didn't do is not relevant to the present inquiry. So it's a different set of rules. It's a different set of standards since the village revamped its entire zoning code. The last thing that I want to mention is I think the due process argument related to the constitutional claims, I think, is a red herring for a couple of reasons. One, it's not a religious organization. And so I think that, that's probably the end of it. But if they want to sue us in federal court and argue constitutional protections that our zoning code, the structure of our zoning code is unconstitutional or is not, in compliance with federal case law, fine, they can do that. But it's not this body's area. It's not this body's lane to analyze that stuff. That's the stuff for federal court or state court, wherever it might be venued, to argue those things in a venue that's equipped to handle those arguments. The purpose and intent of the Board of Appeals is basically to evaluate, hey, what does it say in the zoning code? Did the director apply the code properly as written? Yes or no? That's the end of it. And I do think that there's sort of the specter of that argument that's hanging out there that, well, if you don't give us what we want, we're going to sue you, which I don't think is appropriate. So I don't think that we have to get into the third issue, but the main arguments were office and event uses are permitted. They're not. They're accessory uses. We never get there because of the fact that the principal use is as a fraternal lodge, as defined by all of their materials, as we've seen. And again, what happened to the Legion Post is totally irrelevant. So we would ask that the Board of Appeals sustain the decision to deny the occupancy permit and entertain a motion to sustain that in that manner.
Questions for Attorney Bayer first?
Does a variance come into play here?
Unfortunately, no. That's not what's before the body tonight.
I understand that,
Yeah.
but I mean, is there another approach to come back and ask for a variance? Or
I'm hesitant to even go there because it suggests consideration of factors that are not relevant to the question of whether the zoning code was properly applied.
I'm trying to
yeah, I mean,
understand. I'm trying to understand. The village changed the zoning a few years ago. It was.
It
zoned.
did, yeah.
Okay,
it
so
did, yeah.
it was in the zone and now it's not in the zone, and there would have to be a variance to go around the zone. Because right now it's not,
There are no use variances.
there are no use.
Yeah.
Okay. That's,
Yep.
Additional questions for Attorney Bayer? Hearing none, I think Petitioners Council wanted to make a follow-up comment.
I'll be very brief. I don't disagree with a lot of the things that Attorney Baer said, but the language that he's talking to about classifying us as a community assemblies is it also includes fraternal organizations. It doesn't say lodges. It says fraternal organizations. Fraternal organization is not a use. It's an occupant. It's an owner. It's who is using the property, not how the property is being used. And the primary tenet of the zoning code is that the zoning code has to address uses, traffic, parking, noise, nuisances. That's why we have zoning codes, is to regulate how those externalities impact other people and to make sure uses are compatible. You can't regulate whether it's the Masons or the American Legion or the Children's Dyslexia Center or any other operator, meeting venue, office, get-together venue. It's about how they're using the property. It has to be, not who's using the property.
So just to follow up on that comment, if the community's assembly subsection seems to identify a use, which is hosting public or private meetings by things including senior centers, community centers, performing arts, religious institutions, fraternal organizations. So for that use, does that apply to the petitioner?
I think I think the language is important, just like what you said. Senior centers, community centers, municipal owned performing arts centers, religious institutions, none of those are us. So those are uses. Those are not uses we're proposing. Then you get to, it also includes fraternal organizations. So now you're saying, now your code is saying it's that particular type of user is how they're trying to regulate. And I think that is dangerous to start regulating based on who the user is, where there's an alternative, which is if you look at how we're using the property, office, event venues, which are permitted uses also, we don't have to get into the dangerous ground of regulating who is using it as opposed to how.
Couldn't this just as easily be interpreted as stating including senior centers, community centers, performing arts centers, religious institutions, and fraternal organizations?
Oh, but there's no use just with the fraternal organization.
Isn't it
Fraternal
hosting public or private meetings?
We are hosting meetings, and our meetings are, we think, allowed under office uses, event uses.
I guess to piggyback off of this, we don't have your original application, but it's quoted in the email that we received today. And it says that the primary use of the property will be for Masonic activity. Is that correct?
I'm sorry, I missed your comment.
It says that in your original application, the primary use was stated to be for Masonic activities.
Masonic activities, operations base. And I mean, it's a thick application, so we're
Sure.
focusing on a couple of words.
But knowing that, that this organization is a fraternal organization, that not be interpreted as the primary use of the property will be for the fraternal organization's activity.
And what are those activities? Office uses, event venues, general get-togethers, all things that are permitted or
Sure,
could be permitted.
but that's
under
not what the
interpretation.
application said. It was specifically for fraternities, not in general. So I think
We include not just the Masons, but also our potential tenants as well.
in the original application.
Yes.
So would you categorize the activities as a commercial enterprise?
It's not commercial enterprise, I think. It's office, and some of them, to your question before, were, will we be charging, or will some of our tenants be charging for some of the services? Yes.
For a profit?
Yes. Children's sorry, I have trouble saying that word. Dyslexia Center. Yes.
But the petitioner?
Would the petitioner be charging for services? I don't think we'll be charging for services. Our mission is to provide special events and activities for the community.
So the petitioner is not engaging in commercial event space business? Would you say that?
To further our mission, we actually will be, our plan is to make the event venue available for rent, for profit, to raise for the mission. Yes.
Okay. Would you say that's
So for instance, we would welcome members of the community who wanted to host an anniversary party there. And there
for a
would be a
fee
charge.
for profit? Okay.
I'm also going to interject for your consideration that as both parties discuss the definition of community assembly, the manner in which the sentence and paragraph are written, the subject of the paragraph begins with the community assembly use category. And then it lists the descriptors. So you can interpret that categorization as the subject is the use category, and the remainder of the descriptors that follow modify that subject.
Additional questions for either counsel for parties? Any additional evidence that needs to be presented? I'll note that I don't believe Attorney Bayer's exhibits were included in the original packet, and I just want to confirm it's exhibits A through H. Is that correct?
That's correct. And so they were, A and B were excerpts, merely excerpts of the existing Village of Shorewood zoning code. C was a printout of the homepage of the lodge's website. D was a printout of the links page linking to the Wisconsin Grand Lodge home. Then Exhibit E was an excerpt of the state's website discussing the Freemasonry being the fraternal organization. Exhibit G was some frequently asked questions where it also self-identified as the fraternal organization. And E was the question related to, or excuse me, H was the last one, which was again an excerpt of the website indicating that Freemasonry is not a religion nor a substitute for religion. So those were the exhibits in their order.
Thank you. And I believe that there was reference to, we also had, in addition to the agenda packet, the email from the denial email dated October 30th, 2025.
That's right. And the other thing I just wanted to mention, it was in the packet. The original application that listed the primary uses for Masonic activities, or the main use or the primary use, is also in the which is also an existing part of the record because it was in the meeting packet.
I have a question. This is not a variance.
You're going to
affirm or deny.
You're going to affirm that the classification and therefore the denial of the application reasonable, proper. You're going to overturn it, or you're going to develop potential modifications either for the applicant's consideration or that you would justify granting a permit or ordering.
So clarify, you overturn it, what happens?
Likely that will be a decision that prompts the issuance of a permit.
Prompt you.
Correct.
Would we also have to make a finding that it is a commercial use?
What I would suggest is that if you overturn the denial, you remand it, so to speak, so that the applicant's presentation of what it considers its proper use classified as can be considered by the director.
And so for simple purposes, the question is whether the village made a error or a mistake in categorizing the application as for a, I want to make sure, community assembly.
The lodge's use of proposed request for an occupancy permit in response to a use.
Okay.
I would ask, so right now they're,
No, I believe they sold that property, right? Right now, if I understand the presentation, they have a contract to purchase the property here. I don't know whether it's dependent on an approval of the occupancy permit or not.
so my question is, if they were in White operating, that ordinance similar.
I don't know.
Comment?
Well, I wanted to comment, we're homeless at the moment. So we are without a home. We have this property under contract. Just one other clarification. Our October 20th letter should also be part of the record. There were some questions that the building inspector had. I'm not sure that appeared, but just like Attorney Bayer wanted to be sure that was complete. And then There are other Masonic lodges, just wanted to offer up, that are more than 50% for rental event venues. That's not what we're proposing, but that is the case at other locations.
So you
For that,
represent an October 20 letter?
Yes,
Or an
Oh,
email?
October 2nd?
October 20.
mm,
I don't see that in the packet.
yeah,
Sure. Does that in some fashion expand on
I
the,
mean, it's,
the development of the classification?
Responded to the questions he had. There was some back and forth because there wasn't a clear cut case, and we responded to the building inspector's questions to clarify our use.
would you like to provide a summary of this? I'm not sure if we have, none of us have seen this.
Yeah, it may prove difficult to take a vote tonight if that in some fashion, if you believe in some fashion that would influence the board's consideration.
I'm sorry.
Well, the documents that we did receive for tonight do show what appears to be an email from Griepentrag dated October 16th of 2025 to a J.A. Reek, as well as Ms. Tomzik. Ms. Tomzik responded on October 20th, 2025 by what appears to be email as well. But that email is very brief because it apparently had an attachment to it, which is presumably the document that Mr. Worth is reviewing right now. But that attachment was not made a part of any of the documentation submitted to this board as of yet. And since that documentation responds to a number of specific questions that Mr. Griepentrag asked, that I presume would be significant for his consideration in his determination as to whether or not to deny or grant this permit is something that we have to consider. And even if we ran out right now and made 5 copies of it, I don't think it would be appropriate for us to start wading through that in the hope of reaching some position tonight where we could vote. So my suggestion might be, as Mr. Bear approaches the microphone, that we have an opportunity to get that additional information, adjourn this hearing to allow it to be considered,
Or at least made part of the record.
or at least correct, Mr. Worth. And at that point, we may be in a better position to reach a decision.
Attorney Bear, comment?
I would respectfully submit that doesn't matter. And the reason for that is this body is evaluating on its own based upon the evidence provided by the applicant tonight, whether it comports with the ordinance or not, whether it comports with the zoning. They've had the opportunity to put in any and all of the evidence that they believe is relevant to answering the question as to whether the principal use is as a fraternal organization or not. And they've done that. So it doesn't matter. If during the process, the director said, give us some more information, and I've seen that, frankly, it all relates to the accessory uses, which are accessory or secondary uses, which you never get to again because of the problem of the monopoly problem we talked about. I think it's totally and completely irrelevant. It doesn't make any difference because this body is deciding fresh with a fresh look on its own based upon the evidence presented, whether it meets the zoning or not. I think it's a red herring.
Is
I
there
could
a position?
respectfully request that our understanding was that just as that the questions were asked, the October 20th response should be part of the record at this body, and certainly something that the building inspector considered.
So is your position in agreement with possible adjournment of this meeting for consideration of that email to meet again for voting at another time?
The October 20th letter definitely needs to be part of the record. If that's not something that can be considered tonight, then I appreciate that people may need time to review it.
Could I ask a question?
Yes.
I just was curious if the applicant thought that did you think it was part of the record because it was
Yes.
referenced? Knowing that, I would stipulate to adding it then. I still think it's completely irrelevant, but I can see how reviewing the packet, if you saw the email and didn't realize the attachment was part of it, I never ever want to hit somebody on a procedural issue or a mistake about an exhibit. So if that's the case, I have no problem with it. I still maintain it's totally and completely irrelevant, but if it was thought to be part of what had been submitted and it's going to want to be there for further argument on appeal if this goes up, I have no problem with that.
Okay, so no objection to entering that evidence into the record. However, that doesn't address whether we have adequate time to consider the evidence at this meeting.
Well, and I think it doesn't address whether or not it's important or relevant or not, or whether you need.
But we
it.
can't really decide whether it's important or relevant until we know what it says, right? So
As long as the response.
It's a 3-page letter.
So now I guess you guys have to decide whether or not what you've heard tonight can help you reach a conclusion on whether the classification as community assembly was properly reached, or if there's additional information you want. I think it's, I don't want to put words in the applicant's mouth, but I believe that if the definition was proper, or if the classification of use was properly arrived at, I think the applicant concedes that it can't succeed under the locational limitations. But really, that's the primary question is, was the classification of use properly arrived at?
All right, so if we're entering into, if we would like to enter into a deliberations phase, I'll ask, is there any additional evidence that needs to be presented at this time from either party? No? Any questions that still need to be answered by board members?
I've never seen this in here. We ever talk privately by ourselves?
I don't.
Have to be. Like we wanted, we heard privately.
We would have to have noticed potential closed session. We can do that in the future. You want to have a closed session before you reconvene?
But what would that fall? Or
It have to involve, it can be understood to involve litigation that is or may fall under that.
On the surface, it seems pretty simple. Really not. Talk about it and see how. I know we're going to have a public discussion of that, but somehow I feel it might be better to, proceed that with private. Fixed.
Does anyone have any feeling about whether we want to, well, I'll ask. I move to close the portion of this meeting where we consider evidence and enter into a deliberation phase. Is there a second to that motion? Thank you. Okay, so I think we have options here. It sounds like there has been a suggestion that we adjourn this meeting for consideration of that October 20th email. We would need to meet again after we've all had an opportunity to review that email and then make a decision on whether the village made a mistake or not. Does anyone feel strongly that that is the appropriate path here? I have not read this email. I don't know what it says. I assume that it's been summarized by petitioner's counsel, but I don't know for sure. Is there any comment on that proposed course of action?
That require a vote.
I think it would require a vote to adjourn the meeting for
Correct.
consideration of evidence that wasn't presented to the board prior to the beginning of the meeting.
One of the options available to you under the ordinance.
I'm fine either way. I could vote now without it.
I suppose if there was an advocate for adjourning the meeting, they would have to make a motion for voting by the board members. And we would have to have a majority of the quorum to pass that.
Yes.
Well, I would so move. Based on the information that I heard tonight, I think it's conceivable that we could reach an appropriate conclusion. However, I'm only on this board for coming up on a year, and sometimes I open the agenda packets and I see, oh, this is only 297 pages. And now tonight we have an awful lot of information. We have a multi-exhibit packet that were handed at the time of the meeting. We have another document that references an attachment, a responsive attachment that we don't see. I think it's not appropriate for this group to rush a decision simply for the sake of deciding. I think it's entirely appropriate to reach a decision after we've had an opportunity to review all of the submitted information, and we haven't seen that. So therefore, I move that the board be supplied with the additional exhibit or attachment to the October 2025 email from Attorney Tomzik, and that we reconvene, and after having had an opportunity to review that, and I, whether it's appropriate or not, would further move that the meeting notice for the next adjourned meeting include a reservation of right to adjourn to closed session should the body determine that be appropriate.
There, I think I could get bored with, but I don't know if I would want to. We're doing that for fear of future, and we're not here to assess whether or not the village made an error in how they interpret the code when the application was made. We're not here to, for lack of a better term, protect the village from future litigation based off of our decision here. So if everyone else wants to, that's fine, but I'd prefer those two separate motions not looped together.
I tend to agree. I prefer to have discussions in open session. I've never participated in a closed session. I'm not sure that there is need to have closed session. If additional guidance or clarification is needed, then I don't know why that can't be conducted on the record. So I would agree that if a motion is made for entering into closed session, I would prefer that to be separate so that I can vote for the adjournment of tonight's meeting, because in principle, I think that we should consider all evidence before making a vote. But I don't necessarily agree with the closed session proposal.
So you can amend your motion to just essentially be a 535-55 sub C motion to adjourn for additional case consideration. Additional.
535,
55.
55C.
Does he have to cite to the
He doesn't. He does-
subsection?
No, he doesn't have to. But
All right, then I would revise the motion to remove that portion that related to the opportunity to adjourn into closed session, and simply move to adjourn the meeting to allow us to further consider the additional information that is not available this evening.
I'll second that motion. Is there any additional deliberation before we move to a vote on that motion?
I think that their background is important. Use, respondent talking that there was an attempt to use this property for other use. Didn't meet, I mean, it's too bad the guy bought the property, but seems to be a really limited space in the community. I mean, I drive by that building every day. And trying to figure out in my own mind what's equitable here. I understand the ordinance, I get the zone, but let's talk about Village of Shorewood. Let's talk about action, hold till we decide going. Well, we always have a court remedy. Hopefully go to that. So that's why I wanted to have private discussion. I understand from my study materials when I joined this, we cannot meet ad hoc in the hallway. So why I wanted to be more formal about it. It's just my feeling. Others may disagree, but there's a lot more stake here than just being an ordinance. That's my opinion. Others may.
So I'm not very knowledgeable about the decision-making to enter into a closed session, but is there maybe some guidance you can provide us? If that was something we wanted to do, how would we go about doing that?
Well, it would have to be it would have to be noticed on an agenda. It's a little unusual to go into a closed session for a quasi-judicial. And I can assure this board that if there are questions that have to do with evidence that's been presented, arguments that's been presented, and interpretation of the ordinances, I'm more than willing to put that on the record. But I would, what I would suggest tonight is if there is a vote to adjourn for further consideration of evidence, do that. And any noticed closed session, if the board through you determines that it's necessary, that can be, that doesn't have to be decided this evening.
So does the decision to enter into closed session, that does not need to be pursuant to a motion made tonight?
Doesn't have to be pursuant to a motion.
Okay.
But we do have to cite the reason why we would. be
You have
moving
to
it.
cite a legal
Yeah.
reason. Yep.
There are certain like
An issue.
station or
Financial
matter.
consideration.
Issue.
no, is that a?
It would have to be the village's financial considerations. It
Yeah.
would have to jeopardize the negotiation of a contract or the,
You'd have to look at
payment
the
thereof.
statute.
right.
Oh, yeah.
Which is why I would suggest that it doesn't have to be the subject of the evening.
Mhm.
Especially not if.
Okay.
My understanding session would what is cited.
Correct.
Talk about potential future litigation, wouldn't be able. That
No,
would-
not
that-
about. So, heard the use,
But that wouldn't,
the value of the property, in terms of value for revenue. Are they a fraternity?
I understand that, but we wouldn't be able to talk because it only,
Is that true?
It-
I don't
it-
know.
Yeah, a closed session is a closed session, keeping in mind that the state of Wisconsin is. Closed session has a limited statutory series of questions that can be addressed under the attorney-client privileges. So you would not be able to, the kinds of things that you're talking about of interest to you and of concern to you are absolutely proper for open session, for open on the record. That informs your decision and helps any further review understand why you're getting. So you're absolutely correct. If the decision is to go into closed session, it would be essentially for attorney legal advice, not for a discussion of.
Okay. Any further deliberation on the proposed motion before we proceed to a vote? Hearing none. Toya, can you call a vote, please?
Kara Espera.
Can you read, excuse me,
Mhm.
read the
So Kevin Matthews moved to adjourn the meeting to a later date to review all materials submitted into evidence in tonight's meeting, together with the October 20th, 2025 email correspondence that was not included in tonight's agenda packet, and it was seconded by Wendy Smith.
Aye.
Oh, sorry. Kara Espera,
Aye.
John Tutenhoff,
Aye.
Wendy Smith,
Aye.
Stephen Isaacson, Kevin Matthews.
Aye.
Motion carried 5-0.
So we will adjourn for consideration of that new evidence. Toya, can you coordinate how we can get a copy of that email prior to since there is one?
I will, I'll do a, amended or updated agenda. Well, it'll be a new agenda packet.
Okay, and it will
That'll
include that.
include this.
Okay.
Yes, and is it okay that I keep this? Okay.
Okay.
So are you going to reschedule the meeting as soon as possible, or did we have to?
I'd have to let you know. I think it would be really, contingent upon the members. Maybe we'll do a doodle poll. I'm not sure how to go about doing it. We've never done this before. So,
Could we also include the power station?
is that okay to save? Okay, I'll save the PowerPoint.
For both parties, attorney.
I have Attorney
Oh,
Bears.
we have paper copies
Yeah.
of
Yeah.
the electronic
So
stuff.
I will save the
I
PowerPoint
would
as
still
well.
I would still include that in the packet,
Correct.
because if it does happen to require additional review beyond this board, a single.
And then for both attorneys, if there is material that I forgot, just let me know. I would rather have you guys get an extra set of eyes before I launch it off on the webpage.
With no other items on our agenda, do I have a motion to adjourn this meeting? I guess we already kind of
Yeah,
adjourned
we
this
did.
meeting, do we? Okay, so then
Done.
we can go home. This meeting is adjourned. Thank you.
Thank you. Thank you for attending. I will now end the meeting.